Okay. And as we did before for our previous session, and I'll just give you the information on where you can listen later. If you want to call our bylaws information line, you can dial 641-715-3800 and then use the access code, hold on, 78458 followed by the pound sign. And that will take you into an introductory recording, which will give you a lot of information on how to listen to these recorded calls, as well as how to listen to the bylaws themselves. Okay. All right, I'm going to attempt to read you the instructions about the Q&A session because I'm having difficulty starting the recording of it. So, and I hope you'll all forgive me. My Braille reading skills are very slow, but that's what we have. So, Q&A session basically means that everybody who is a participant in the call is muted. And in order to get into the queue to answer, to have a question asked and answered at the appropriate time in this call, what you'll do is you'll press *6, and then you will press the number 1 to get in the queue. Now, suppose you change your mind and you want to get your name back out of the queue, then what you'll do is press *6 again, and then 2 removes you from the queue. So you know. On other conference calls, *6 basically mutes and unmutes. That's not the case for this because all participants are already muted. Okay, so when we will let you know when it's the time to open for questions because some questions have been emailed in and those will be dealt with first, and then when it's time, we'll let you know and remind you that *6 and then 1 gets you into the queue. Also, I'd like to remind everybody that it's the policy of the GDUI board that we do not like to have anonymous callers on our conference calls. We feel that it's important for people to not block their identity, and so because caller ID is shown on the conference call, we do drop calls that are marked anonymous. If you've got your number blocked, I would request that you please hang up and call back again, revealing a phone number. And we appreciate your cooperation in that. Okay. Well, welcome everybody to our second of the 2 bylaws information conference calls that the GDUI board has offered for the benefit of the membership to keep the membership informed. I'm Lori Mehta, GDUI's president, and I welcome you here and appreciate your participation. Our first call that we had back on March the 20th was extremely well attended. We had about I think it was a little over 50 callers, and that was great. And I know that a lot of people have listened to the recording of that call already. And as we announced before, for those of you who just came in, this call is being recorded and will be available for people to listen to. A little bit of history here. Basically, this is an extremely important issue for GDUI. GDUI needs to have legally compliant bylaws. As will be explained in greater detail later, the law of the District of Columbia that GDUI must adhere to changed, and the new law went into effect, or the changed law went into effect as of January 1st, 2012. Before that, the IRS changed a bunch of things which, deal with nonprofits and what nonprofits are required to do, and I believe that was the inspiration for D.C. to change its law. But at any rate, in the spring of 2012, the GDUI board was made aware that the law had changed and that there would be things that GDUI had to do to make some changes to go along with it, to follow the law. I do not know why the Constitution Committee in 2012 did not address those issues more directly or more fully or at all. I can't answer that for you. I was on the board at the time, but I was not on the Constitution Committee. As you know, I was elected to serve as GDUI president, and that election took place in the very late spring. And when I did learn that I had been elected by you, the membership, my first task was to try to do an awful lot of research to find out things that I needed to do and that GDUI needs to do. And I sought out some very good legal resources, including people within ACB, people who are not affiliated with ACB at all, parliamentarians. I really tried to draw upon whatever resources were available, and I was informed that GDUI's constitution was actually quite poorly constructed. Two different parliamentarians, certified parliamentarians, informed me that this was going to present a lot of problems for GDUI, and they recommended that I seek some assistance to get, the Constitution Committee some help in revising or redrafting the Constitution. A lot of stuff that was begun did get delayed significantly due to the issues that happened in August of 2012, and basically I wasn't able to do, no officer of GDUI was able to do their job for a few months. But when we came back following the membership's outreach to the Attorney General's office, we were advised by the Attorney General's office that, yes, indeed, you need to do something about your Constitution. It's not in compliance with the current law, and we were referred to legal resources. And ever since that point in time, the GDUI board has been working very hard, very thoughtfully with legal resources to do what needs to be done to bring GDUI into full compliance with the law and best practices for nonprofits. So the board has put a lot of thought, a lot of work into this. We've worked very closely with legal counsel. The end result has been a very good, solid legal document, a bylaws that GDUI can really stand on and grow from, grow with. The board has discussed this document, given input, and the board has come to the conclusion that the board recommends this proposed new bylaws for member adoption. And we want to get this information out to members as best as possible because this is so important for GDUI. It's now the spring of 2014. The law changed as of the beginning of 2012, and so it's all long overdue. So without further ado, I would like to introduce to you our Constitution and Bylaws Committee Chair, Mary Beth Metzger, and then following that, I will introduce to you legal counsel that has assisted GDUI in drafting these bylaws for member adoption. So,
hi, I'm Mary Beth Metzger. I just first like to thank all the people who took time out from your busy schedules to come. Maybe bylaws aren't the most thrilling thing to talk about, but they are really critical. And thanks so much for taking the time to come. I do, of course, want to thank Regina so much for the help that she's given us and the time. And so I'm just looking forward to listening to questions and answers with all the rest of you during this time period. Thank you.
Okay, thanks, Mary Beth. And so I'd like to now introduce to you legal counsel that has assisted GDUI and closely guided the process of drafting these bylaws. And she is an expert in the law of the District of Columbia, particularly nonprofit law. And I believe that what she would like to do is offer you somewhat of an overview, and then she's going to address some of the questions that have come in via email. And then at that point, I will announce our question and answer session for those of you who are here live. So, Ms. Hopkins, we welcome you here. Thank you for coming and for making your services available to GDUI.
Thank you, Lori. My name is, it's a pleasure to do so. My name is Regina Hopkins, and I am an attorney. I have been a tax attorney my entire career of 30-plus years, and in particular, I have focused in on nonprofit legal issues for approximately 24 years, not quite 25 years. And I previously worked as a general counsel for an international nonprofit before I came to the D.C. Bar 8 years ago with the mission of working with nonprofit organizations in the District of Columbia. I'd like to sort of give a little bit of an overview. As Lori mentioned, in 2012, well, actually it was passed in 2011, but effective January 1, 2012, the D.C. Nonprofit Code was completely amended and restated. Virtually nothing from the old code survives. It was modeled on the model nonprofit code published by the American Bar Association. And these bylaws have been drafted so they come in compliance with the basic provisions of that code. In addition, we made some additional changes to comply with what are considered best practices in nonprofit legal bylaws. And so those are the intention that we have when we started working on these bylaws. So basically, let me just give you a quick overview of the bylaws for those of you who may have them in front of you. It's the first thing is Article 1 is the name of the organization. Article 2 is the purposes of the corporation. Some people have asked about why do we not set forth the mission of the organization in the bylaws. Let me explain something. Bylaws are basically a mechanical document. Occasionally people have commented that they're very legalistic. Well, that's because they are at their very nature a legal document. A corporation is an artificial legal construct, and by that I mean that it exists. It has, it's not a person. Well, Mitt Romney notwithstanding, it's not a human being. It's an artificial legal entity created under the law, and in order to be validly incorporated and operating, it has to follow certain legal rules. And the Articles of Incorporation set forth some basic provisions that all nonprofit corporations have to have, both under D.C. law and under the Internal Revenue Code. And the bylaws are basically designed to set forth the rules of the road, the mechanics of how the organization operates. How do they, if they're a membership organization, who's a member? How do they elect? How do the members meet? How do they elect directors? When do the directors meet? Who's the officers of the organization? What do they have the right to operate under committees? It's pretty mechanical stuff. It's not intended to be a mission statement. It's not intended to sort of set forth the vision of the organization. Those are important things, but they're not bylaws things. The bylaws are really just a nuts and bolts. It's like a cookbook, if you will, rather than anything more poetic, if you will. This is the prose part of the equation, not the poetry. As such, it's going to have just a lot of how many days notice, what has to be in the notice, who does the notice go to, how do you have the meeting, sort of dry stuff that is under normal circumstances, not very interesting or controversial. And bylaws, and there's been a clear, in fact, I was just at a training that we sponsor, and that we had a partner at a D.C. law firm who specializes in nonprofit organizations talk about bylaws, and she sort of articulated what I think is the current thought, which is bylaws should be minimalist, meaning because it's an effort to amend the bylaws, because it requires certain procedures and, supermajority votes and things like that, that you should not overload your bylaws with things that don't need to be there. So you try to have just the nuts and bolts and the bare essentials in your bylaws. So with that in mind, Article 2 sets forth the purposes of the corporation, and what it does is, instead of setting them out again, it just incorporates by reference the Articles of Incorporation. That way, if you amend the purposes in the Articles of Incorporation, you don't then have to go and amend them in the bylaws. And the reason why you do it in the Articles, like the amendment is in the Articles, because that's the public document. It's also the one that the IRS most cares about, so you would amend it there. If you change your purposes, you amend it there, and it automatically is amended in the bylaws, and you don't have to take that extra step. The Article 3 provides for offices and registered agents. Every organization must have a registered agent, so that if in any event the organization is ever need to be served with legal papers, there is somebody who is authorized to receive them on behalf of the organization. This is a membership organization, and so Article 4 deals with the members. The first thing you need to know is one of the biggest changes in the new DC nonprofit code is that an individual has to agree to be a member. Under the old law and under most practices, people there's a provision that says anybody who's a donor or anybody who's a volunteer or anybody who supports the mission of the organization can be a member. And the way the law is written, those provisions you can't have provisions like that anymore. You have to say they're eligible to be a member, but you have to set forth some sort of mechanism by which people can actually elect to be a member. So you'll see in 401, we set forth who's eligible to be members, and we say that the board is going to establish a mechanism by which people can actually affirmatively elect to be a member as required by the law. It is the goal. In the old bylaws, there was a statement that said half of the members had to be guide dog users. And the problem with that provision is, and I think I mentioned this last time, is that if you are in a situation where you have 51% are guide dog users and 49% are non-guide dog users, if for some reason those guide dog users cease to be guide dog users, they resign from the organization for whatever reason, or they because of increasing age, they can no longer be a guide dog user, or some other disability, they cease to be guide dog users, then even though they continue to be members, they don't count towards that 50%. So you could have no change or very little change in the membership, but you'd be out of compliance. And then you're in a position of who you're going to kick out to get to that bylaws provision. So after some discussion, we decided that it was appropriate to say that that's the goal, is to have 50% guide dog users. And if it ever falls below 50%, then the corporation shall try to use its best efforts to increase the percentage.
And that protects the membership of the people that cease to be guide dog handlers for whatever reason, right?
Right. And there was someone suggested that I wanted to make them non-voting members. I think based on the last call, I think that was just a misunderstanding of that. It's not that they will cease to be members or voting members. This provision is designed to ensure that they can remain voting members, notwithstanding the fact that they are not able to continue to use guide dogs. We do have provisions for the termination of members. A member may be terminated can choose voluntarily to terminate their membership. We also have a provision which is very common in all the bylaws, sample bylaws that I looked at, that if you fail to pay your dues, then you're automatically no longer a member. Someone asked a question last time, and I'll just reiterate, that you can get reinstated immediately by just paying your dues. I mean, this is not you're not banished or suspended for a period of time. It's just while your dues are not paid, you're not a member. And once they're paid, you immediately become a member. Perhaps the more controversial provision is the provision that says that members can be terminated by a 2/3 vote of all the directors in office at the time, and for provided proper notices given to the member of the proposed termination, including the reasons for the termination. The member shall be given an opportunity to address the proposed termination in writing or in person before the Board of Directors, and then the Board of Directors will make its decision. A couple of things. The current bylaws, I might add, have an unusual provision. As I went back through it, I don't know that people are aware of it. Currently it says, all members in good standing, and then they put parentheses, dues current and no unresolved charges, shall have the right to cast his or her vote at the membership meeting. There's no explanation for what an unresolved charge is, but the suggestion is that if someone makes a charge against you, even if it's not true, it's ultimately proved to be not true, but as long as it's pending, you can be suspended from voting, and that's in the current Constitution. That's in Article 3. I think we also mentioned that the ACB, American Council of the Blind, also has a provision in its bylaws for termination of members with or without cause. In their case, they do it at the annual meeting by the membership, but a couple of things they don't have in that provision. They don't have prior notice of the decision to or the motion to terminate a member. The member is not guaranteed the right to speak. For example, the way their provision is written, you could go to a meeting. Someone could make a motion from the floor without any prior notice saying, I just want to suspend or terminate the membership of Joe. And someone seconds it, and then, boom, there's a vote. And there's no prior notice. They don't even necessarily have to give the reason for it. And it may not be very persuasive, but they don't have to give the reason for it. The member doesn't even have to be known. I mean, the member may not be there at the meeting. There's no guarantee that the member will be there to defend themselves because there's no prior notice. So you may have a conflict. You don't go to the ACB meeting, and you find out after the fact that someone made a motion from the floor to terminate your membership, and it was adopted, and you had no rights whatsoever. You're out of the organization. That is what the bylaws provide. And that's, that can be abused. Now, I'm sure that doesn't happen at ACB. I'm sure, people don't like to try to do that, but it's certainly permitted under their bylaws. So what we have here is, I think, a very reasonable provision. I did a lot of research on this provision before I suggested it. I just want to make clear that this was my recommendation, that some provision for terminating membership should be in there and have a lot more protection than what's in the current bylaws. And what it requires a supermajority vote of the board. It requires 2/3 of all directors, so that if you have a meeting and let's say there's 11 directors, and you have a meeting and of 7 directors show up, that's a quorum for the meeting. And let's say 2/3 of them vote to expel a member. That's not valid because it's not 2/3 of 11. This works better if I use 12. That's an even number. It's not 8. It's not the vote of 8 people, which is 2/3. You need a 2/3 of all directors, whether or not they're at the meeting. So if you have less than 2/3 present in a meeting, they can't vote to expel somebody. Second, the person who's the subject of the termination has to be given advance notice to the same extent as the directors, so that they know in advance that this is going to be a subject. They have to be told the reason for the proposed termination, so they have advance notice so they can respond. They have the right to address the board about the proposed termination, and if they can't be there in person, they have a right to address it in writing. Those are all procedural safeguards that are there to ensure that the person has notice and an opportunity to be heard before the decision is taken. I think, people suggest that, people may be unfair, but there's no guarantee under any provision. Any provision can be abused. And as I mentioned last time, I think that, for example, if someone wants to make an allegation against somebody that's salacious, for example, a lot of times people may decide to resign rather than go through the hearing at a public forum like a meeting, like an annual convention. And I can see very many instances where someone may enjoy the relative privacy of a board meeting rather than a meeting with hundreds of people in the room, where they could be embarrassed by false charges, much less true ones. So that's the provision. Some people like it, some people may not. It's just something you have to take into account. I don't think it's an unreasonable provision. We do provide for non-voting members. I have to say every sample, and I went back and checked today, every sample document I looked at, you look at the Minnesota Nonprofit Association or go on the Georgia or California, there are numerous sample nonprofit bylaws out there, and every one of them has a provision for non-voting members. These are, it's not designed to create second-class members, but rather as a way for people who choose not to pay the dues for whatever reason, as a way for them to be connected with the organization without having to pay the dues. And they don't, and because they're not dues paying, they don't have voting rights, but they have the opportunity to have some connection. And I use some examples of kids in school, maybe people who are, family members that want to have the honorary membership, but they don't want to be the dues paying. This gives them the choice. And they're still eligible to pay dues and become a member. Nothing takes away from that. But it does give them a second chance to be connected with the organization without having to be dues-paying members. There is an annual meeting of the members, and it's slated for the second quarter of the year. There has been some suggestion that the board can cancel the annual meeting and run by the organization on their own. That's not true. There is a provision in the bylaws that says failure to hold an annual meeting does not invalidate the corporation's existence or affect otherwise valid corporate acts. And that is right from the statute. And what it provides is that if for any reason, let's say there's a natural disaster or something, some reason that the annual meeting is not held, the corporation doesn't go out of existence and it still can act, it can do its legally sufficient duties, like file reports and things like that. The fact that they weren't able for whatever reason to have an annual meeting does not result in the dissolution of the company. That's all it's saying. So there has to be an annual meeting, but it is possible for certain circumstances to occur that could result in the cancellation. If that happens, then the corporation does not go out of existence. There's also a provision for special meetings. The president can call a special meeting, the board of directors can call a special meeting, or 25% of the members can call a special meeting. I might add, there's been some complaints about the new bylaws that they take away member rights and give them to the board. And I would say that this is one case where that's just not true. The current bylaws do not have any provision at all for members to call a special meeting. The only way a special meeting can be called under the existing bylaws is for the board to call it. So this actually gives members more rights than what they have under the current Constitution. It sets, under statute, you have to have between 10 and 25% of the members is the range. Threshold to call a special meeting, it can be set anywhere between 10 and 25%. We went with 25%. I think I said last time that I think that's probably going to be the most common one. The reason why the quorum is 15% of the members. So it doesn't make any sense to call a special meeting when you can't even guarantee a quorum, because this is a special meeting. This is, a physical meeting. Someone's going to have to rent a space and pay the cost, and people are going to have to go to the expense of going to the meeting. So it should not be something that's done all the time. It should be, it's reserved for important occasions. And so it shouldn't, if you can't even get enough people interested in having a special meeting to satisfy the quorum requirement, it seems crazy to go to all that expense to have a special meeting. I mean, 25%, that's only a quarter of the members. So if a quarter of the members, if you can't get a quarter of the members interested or to agree with you, then, I think you're hard-pressed to say that you should have a special meeting when there seems to be so little support and or interest in the issue that it has to require a special as opposed to a regular meeting. There is one of the big changes in the law is a requirement. I'm going to say this clearly. It is a requirement that there be a record date. A record date is the date on which you determine whether or not someone is a member for purposes of setting up the voting list. The statute has two provisions. In 40507, they provide that either the bylaws can set the record date or the board can set the record date. 405.05 says that if neither the board nor the bylaws set a record date, then the record date shall be the day before notice is given to the members. Now, basically, what the statute says is that you will have a record date. It's going to be the day before notice is mailed unless there's some other provision in the bylaws or by resolution of the board to set a different record date. But the record date that they set can't be more than, I think it's 10 days before notice is given. So we're talking about the difference between 1 day and 10 days before notice is given. But it has to be set, and if the board doesn't set it, the bylaws don't set it, the statute does. That's not really open for dispute, although some people have suggested that there's no requirement for a record date. There has to be notice of a meeting. The quorum carries over for 15%. Another question that came up, or comment that people have had, is the president shall determine the order of business and has the authority to establish rules for the conduct of the meeting. The statute provides that there has to be a presiding officer of the membership meeting. And it specifically states, that, I'm trying to think, find exactly where it says. It specifically states that the presiding officer shall determine the order of business and has the authority to establish rules for the conduct of the meeting. So basically, that's word for word right out of the statute. And the president is the presiding officer because that's what the president does. That's one of the jobs that a president typically has with an organization. They preside at meetings. If you think someone's qualified to be president, then that's one of the things, determinations that you have to make and figure out who you want to vote for president is how you think they'll do that job. But that's the job of the president. And like I said, the idea that shall determine the order of business and has the authority to establish rules for the conduct of business, that somehow that is a usurpation of authority is just not true. That's right, word for word from the statute. Bylaws do provide for a means of by conference call. There has been some question about that as well. Basically, what the statute provides is that it allows members to meet by conference call or similar communications equipment if all persons participating can hear one another, vote on matters, pose questions, and make comments. The statute, this is actually a little bit narrower than what the statute authorizes. The statute authorizes meetings through the Internet and where the material is conveyed in written form. And it says because material can be conveyed over the Internet in written form, there is a requirement that it be held simultaneously or contemporaneously, that it's not recorded or delayed or after the fact. I think the statute actually says substantially concurrently with their occurrence. Because we didn't put in a provision for an Internet meeting where the material or the information is conveyed in writing, we did not put in the language that says that the proceedings, that they have the right to read the proceedings substantially concurrently with their occurrence. We put in a provision for conference calls. Conference calls, by definition, are concurrent. They're done in real time. They are not done on a delayed basis, unlike written material, which can be either real time or not real time. In fact, it's more often not done in real time. So that is why there's a slight deviation from the language, because we are not having written meetings where the information is communicated in writing. There has been some question about what is the function of the board of directors and whether all the authority has been given to the board. What the bylaws say is the business and affairs of the corporation shall be managed under the direction of the board of directors, which shall determine matters of policy in accordance with the provisions of the articles of incorporation, bylaws, and the nonprofit code. It does say that they can delegate management to committees or one or more persons, but ultimately, if they delegate authority, the board has ultimate responsibility, even though the authority may be delegated. Again, this is pretty much from the statute. There's nothing extraordinary in that. That's what boards do. They have the authority to run the organization. Here it is, right from the statute. A nonprofit corporation shall have a board of directors. And it says, except as otherwise provided herein, all corporate powers shall be exercised by or under the authority of the board, and the activities and affairs of the corporation shall be managed by or under the direction and subject to the oversight of its board of directors. So the statute, that's what a board does. It's pretty, it has the general authority to run the affairs of the organization. The members, just like shareholders in a private corporation, their basic role is to pick people who would be good directors. And it's the board of directors' basic responsibility to carry out the affairs of the organization. I just want to take this time to explain that the board, cannot do this recklessly or, just do what they feel like. As a board member is a fiduciary. What that means is that instead of acting on their own behalf, like a member or a shareholder in a for-profit corporation who are acting on their own behalf, a board member is acting on behalf of the members or shareholders in the case of a for-profit corporation. They are they have fiduciary duties, and what that means is they have to carry out their duties with the care that a prudent person normally would carry out when exercising important responsibilities. They have a duty of care, which means that they have to be careful and exercise good judgment when carrying out their responsibilities. They have to attend meetings, be prepared, be engaged. They can't be absentee directors. They have a duty of loyalty, which means to put the affairs of the organization first and above their own personal interests. They can't engage in conflicts of interest. They can't, sacrifice what is in the best interest of the organization to some other entity or some other person. And they have a duty of obedience, which means that they have to follow the provisions of the Articles of Incorporation and bylaws and D.C. law and federal law. Those are minimum duties that they must exercise under the laws of the District of Columbia, indeed the laws of every state in the United States. And so whatever functions or powers authority they're given under this bylaws have to be exercised in that context. So they just can't act irresponsibly or recklessly, but they have to exercise in their duties appropriately. The number of directors is set forth. We have a range here so that if, in fact, someone resigns, you're not automatically in violation of the bylaws. We have, and again, this is my recommendation, and I think people agree with it, that the way to get on the board is you're elected by the members, period. It's the only way to get on the board. You're either elected as an officer or you're elected as a director. In that sense, the board has actually, and the officers have given up some of their powers because under the old bylaws, or the current bylaws, I shouldn't say the old, the current bylaws, there are appointed members of the board. If there's a vacancy, for example, someone who gets elected and they resign 2 months later, the board can appoint someone to take their place for the remainder of their term. There are, editors, track, and affiliate editors, and all of those have the effect of putting people on the board who are not elected by the members. And you could sort of shape the board, and the officers could shape the board that way, the membership of the board that way. That doesn't happen anymore. The only way to get on the board is to be elected by the members. So the members have complete control over who sits on the board. The only caveat is if someone resigns, the board can appoint somebody temporarily until the next annual meeting. So if they resign halfway through the year, then they can be appointed for 6 months just to fill out the term, and then at that point the members have to ratify the appointment of that person. So in that sense, again, this is a case where the board, just like with the right to call a special meeting, where the members actually have greater rights and greater freedom, ownership than before. We do have annual and special meetings of the board and notice. The directors can act by conference call or written consent, and they serve without compensation. There are officers. Article 7 deals with officers. There is a president who is responsible for presiding over the meetings of the organization, the first vice president, the second vice president, a secretary and a treasurer. Generally speaking, they serve for 2-year terms. The vice presidents and the presidents are subject to term limits. The other officers are not. Basically, in order to be an officer, I think you have to be on the board for 1 year in anticipation of that, for a member in good standing for 1 year in order to be eligible. I just want to say something. There is a committee, a nominations or a committee who gets to run for officers and directors. There's been some confusion about that. There is a committee who's responsible for for collecting the nominations for the various officers. Their only function is to verify that the individual meets the requirements to be an officer or a director as set forth in the bylaws, that they're a member of guide dog users in good standing, that they've met the minimum service terms, in the case of, say, president, that they've been a member for a year. That's it. They don't put forward a slate. They don't cull the nominations. They don't make any value judgments. All they determine is that they meet the minimum requirements for eligibility. And then they put forth all the nominations. So anybody can nominate themselves and the committee just screens them to make sure they meet the minimum qualifications. So there's been some suggestion that this committee will declare certain people ineligible. That's not true. It's just not true. They don't have that authority. In compliance with best practices, there were be eliminated a specific reference to committees, named committees in the bylaws. Basically, one of the bigger changes that the new act does is it says that there are two types of committees that a board can appoint. One is a board committee and one is an advisory committee. A board committee is a committee that can act on behalf of the board and make decisions that otherwise would require board approval, like approving a budget or selecting an auditor, or doing something like other things, major decisions on behalf of the organization. Those committees have to be approved by a majority vote of all directors, including, and who is appointed to them, again, must be made by a majority vote of all directors. And only board members can serve on those committees. So think about this. And before, under the old law and under the current bylaws, anybody can be appointed to a committee, whether they're a board member or not, and that committee can be given the authority to act on behalf of the board. And you could almost, in a way, dilute the ability of the members to control who makes the decision. Under the new law and under these proposed bylaws, that doesn't happen. Anybody who's going to act on behalf of the board has to be a board member, i.e. elected by the board member of the board of directors, i.e. elected by the members. They have to be approved. Their appointment to the committee has to be approved by a majority of all the directors, and the charter of the committee has to be approved by a majority of all the directors. So that's a case where, again, I think that helps the members or strengthens their rights rather than diminish them. The board can appoint advisory committees. These are just what their name implies. They give advice, but they can't act on behalf of the board or the corporation, and they don't have to be directors as a result. They're approved by a simple majority. And, you could have like you were having a special event, you could have a planning committee or something like that. And since they're just giving advice, they're not actually have the authority to act. The rules about who can be on the committee are much looser. I won't go through all the technical provisions of Article 9 dealing with indemnification. The statute has very detailed rules about indemnification of officers and directors if they're sued as a result of acting on behalf of the corporation. And this basically just follows, step by step what's in the statute. It's complicated. It's very, you want to talk about legalistic. That's legalistic. There is a miscellaneous provision that talks about the fiscal year, maintaining tax-exempt status, etc. It has an amendment provision that basically traces what's in the statute, which is that the membership, the board can amend the bylaws with certain limitations. And the limitations are as follows. They cannot amend it in any way that it sort of affects members' rights. So the board, if they can't change, they can't remove a director. I'll talk a little bit about in just a second. The way the bylaws are written and the statute's written is any board member, any director who's elected by the members can only be removed by the members unless they have done certain specified bad things. They've been convicted of a crime, they've been held by a court to have breached their fiduciary duty, et cetera, et cetera. There are certain bad acts that everybody agrees would be bad acts. The only one that's sort of not bad, but just is if they miss too many meetings in a row without an excuse, they can also be removed. But otherwise, only the members can remove a director. Similarly, only anything in the bylaws that have to do with the rights of the members, their voting rights, the termination, any provisions relating to the termination or suspension of members, anything that would require or change the definition of cause for removal of a director, changes to the number of terms or officers, anything relating to the manner of levying dues, all of that, anything that would either affect the member directly or their rights to control the organization through the election of directors has to be approved by the members. Otherwise, the more ministerial things or others can be approved by the board. I would add that I went through a dozen sample bylaws that you can find on the internet, and all of them had a provision, without any exception, that the board amended the bylaws, this period. This one gives the board the amends sort of the more general provisions, but things dealing with eligibility for membership, election of directors, removal of directors, removal of members, anything like that can only be amended with the permission of the members. So in that sense, they are protected. No one can use the amendment provisions to circumvent their rights. So it's a lot of change. I appreciate that fact, and there's a lot of questions. It will take a while. You know, the benefit of the current bylaws is people know what they say, and they're comfortable with them because you've operated under them for a period of time. These bylaws are new. They have some new provisions in there, and so people have some questions. But they really are following best practices. They are adhering to the statute, and I think that we've done everything we can to sort of reflect what is considered good practices in the nonprofit arena. So with that, let me get to some of the written questions. I want to say something up front. A couple of people have been sending emails to guide dog users, the bylaws at guidedogusers.org, which is the email that Lori gave and Mary Beth gave last time to send your questions. And then some people have looked up my email address and they've sent it to me directly. I just want to say everything that has been sent to guide dog users has come to me. To the extent that anybody has any apprehension that I am not getting all the questions, you can be rest assured that I get them. And now I get them in multiple forms because they're sent to me 3 or 4 times. So both by Lori and Mary Beth and then by people directly. I have gotten the questions. So you can use the bylaws at GDUI.org address without fear that I will receive them, because I will. So I want to make that clear and not create the impression that there is any problem with communicating to me through that address. Okay. So let's go through some of the questions. This is a series of questions from, let me get the best copy, that's not the best one. This is from Penny Reeder, Will Burley, Don Brown, Betsy Grenovich, I'm sorry if I'm not pronouncing your names correctly, Maria Hansen, Lynn Merrill, Pat Hill, Lillian Scaife, and Sue Martin. It said, they talked about, well, the first thing they said was, that they were complaining or commenting that Lori Mehta did not disclose my name. They knew it all along. But, I just want to say, I think Lori and Mary Beth have been somewhat protective of me. I'll be honest, I've seen some of the emails that have gone back and forth, and the tone of some of them has been, surprising. I remember one of my very first conversation, I think I didn't mention last time, was the first person who called me. Well, first I got a call from the D.C. Attorney General's office asking me if I would speak to the various people involved in the leadership dispute. back in the summer and fall of 2012, and I agreed that I would. And the first person who contacted me was Becky Barnes. And she admitted that the tone in some of the emails and conversations and back and forth were objectionable. I would have to, I think that was her word, or I forget exactly the word, but it was along that tone. She may have said regrettable. I don't disagree with the regrettable part. And so I think they were protective of me. They didn't want me to sort of get caught in the crossfire that has sometimes gone forward on this. I've been a lawyer for over 30 years. I have a pretty thick skin, so that's why I gave my identity. But I don't want anyone to have any sort of assumption that there was anything ill, that they were acting out of bad or improper motives. I think they were just concerned that that people sometimes have fired off emails that, in retrospect, they probably shouldn't have or wouldn't have, and they just wanted to make sure they weren't directed at me. So I just want to express that. They have, I'll go through the specifics before I address their general comments. Provisions that give the board and the president the authority to remove members with or without cause. I think I've addressed that. The lack of recognition with the proposed bylaws of Robert's Rules of Orders as the default parliamentary procedure. Again, I went back and looked today and see if any simple bylaws on the internet had Robert's Rules of Order. It doesn't in their bylaws. It doesn't mean that you can't adopt them as your mode of operation, but you're not required to. I think I made the comment that for small organizations in the last call, it's my experience for over 30 years of doing this, that small organizations without staff and without legal counsel regularly in attendance of the meeting, often, they tend to do things pretty shortcut. Sometimes it's hard to get people to second motion, much less go through the whole thing, all the different dotting of I's and crossing of T's. And so you try to make the bylaws as user-friendly as possible so that there's no penalty if they, don't follow Robert's Rules of Order. They're not in violation of their bylaws. I think that something like Robert's Rules of Orders is great if you have a much larger organization with thousands and thousands of members and paid staff and paid counsel or general counsel or something like that. But that's not the case here. And I just think that to make it a bylaws requirement is to put an onus on the organization that, given their size, is unnecessary. A provision that gives the president authority to call, establish meeting rules, and set the agenda for membership meetings. As I mentioned, I think I made clear that's right from the statute. A provision which gives GDUI membership eligibility criteria in conflict with that of ACB. I don't know what the conflict is with ACB. The only thing we have is that you can have honorary members. Again, I don't think that that's a bad thing. You don't have to, but you can if you want to. Anybody can be a member of GDUI by just paying the dues and doing the paperwork. So it doesn't preclude anybody. It doesn't relegate anybody to honorary membership. It's a self-selection. Diminution of several essential guidelines that have traditionally resided within our current Constitution to the level of board policy. I'm not sure that that's true. The provision in the proposed bylaws that requires 25% of the membership to call a meeting, which will be presided over by the president. Again, the president presides over meetings. It's just the way it is. A 25%, again, I go back and reiterate that under the current bylaws, none of the members, 100% of the members can't call a meeting. There's no provision in the current bylaws for the current Constitution that allows members to call a meeting, period. The absence of any reference to the guide dog users liaison, affiliate liaison, and power tax editors, that's true. As I said, what we did is we decided that to get on the board, you had to be voted on by the members. That was designed to increase the authority of the members over the board rather than having people appointed to the board. Any provision of the proposed bylaws which fails to take into account the unique culture and other organizational aspects of GDUI was set apart from other kinds of non-membership nonprofit organizations. I tried to, let me see how I put it last time, because I think I did it okay last time. I've been involved, I was first approached with this organization in the late summer of 2012. And I have to say the culture of GDUI is not one that I think people would be happy with these days. I think it, whatever the current constitution is, it hasn't protected this organization from a real breakdown and a conflict that has put a real strain on the members of the board, the officers, the members of the organization itself, has interfered with the mission of the organization. That is a culture that I don't think needs to be preserved but needs to be corrected. Someone asked, would this, the current bylaws, prevent a recurrence of what happened in 2012? Sadly, no. And the reason why I say sadly no is because what the people did in 2012 was really outside the scope of the existing bylaws and the statute at the time. They did what they did, even if they were done by the purest of motives, was outside the legal framework for how to operate a nonprofit corporation. And as a result, if someone's going to violate their duty of loyalty, violate their duty of obedience, violate their duty of care, for whatever motives, well-intentioned or not, then they're going to do it. And there's not much you can do to prevent it. They have every director has a duty to obey the bylaws, and several of the people involved in the interim executive committee back in 2012 were board members, and they violated that duty. And so, I mean, if you're going to break the law, you can break the law, regardless of how it's phrased, even if you think you're doing it for a good reason. Okay, the absence of any reference to our affiliation with ACB. I'd like to talk a little bit about ACB. ACB, the American Council of the Blind, is an independent organization. I worked for another nonprofit that had true affiliates in the sense of they were people who shared a common name with the parent. There was a parent organization and local affiliates with the same name. They shared the same tax exemption. We had what was called a group exemption from the IRS, which means that the parent gets the exemption and its affiliates automatically are exempt provided they follow certain requirements. We provided funding to the tune of hundreds of millions of dollars to the affiliates. And we had a shared mission, an identical mission, because we were all one organization in terms of our mission. Even all that, even though the IRS put a duty on the parent to supervise the affairs of the affiliate, even though there was a shared name, a shared tax-exempt status, a shared mission, an identical shared mission, and a shared funding or funding that was passed through, we did not, as the parent, I work for the parent, we did not intervene in the... Hello? Lori?
Yeah, you're here. Yeah.
Okay, I'm sorry, someone's calling me on another line, so I'll ignore that, that's why. Okay. So even with all that, we did not involve ourselves in the running, the drafting of the bylaws or of their conduct of their meetings. We just didn't, because they were independent organizations. we trusted the directors to act in their best interest. And I think that, I got an email from someone who's on the board of ACB who said that he could help me, he would help me draft the bylaws. He thought they were well to make certain changes. And, it's just, there's a line between working with someone and crossing the line and interfering, even if it's done for the best of intentions. And, if ACB hasn't crossed the line, they're standing on top of it, in my opinion. I go back to their ACB website. There's not a shared name. There's not a shared tax exemption. There's not an affiliation agreement, which we had with our affiliates. There's no standards of conduct. There's nothing. It's just the only provision is that members of the local affiliates who transmit part of their dues can get certain voting rights in the same way that other people who pay their dues directly get certain voting rights. And I think that, the only point I would make is I think that it's GDUI has to be, it's the board's responsibility to draft the bylaws and do this. It's the members' responsibility to approve or not approve the bylaws. It's not, any relationship that you have with ACB is outside the internal workings of the organization. And, it could be, you may think it's very important. You may have a lot of dedication to ACB, but it should be, that's not what's supposed to be in the bylaws. The bylaws are about how you hold meetings and how you elect directors, and that's all it is. So, okay, another reference to Robert's Rules of Order. Again, I think I talked about this. And to revoke the membership, I talked about that. Okay, so that's one question. Okay, let's see. Someone says, I wonder what ACB's take on this would be if GDUI has responsibility as a chartered affiliate of ACB. I agree with Charlie that we do not have the responsibility legally to ACB, but morally, traditionally, we do as an affiliate of ACB. You can't have it both ways on one hand. I just want to say that, your first loyalty, the board's first loyalty is GDUI, and you may want to affiliate with ACB, and there's nothing in these bylaws that prevents that, or takes that away, or withdraws that, or anything. It's just an internal document. It's designed for the internal workings of the organization, and it's unrelated to how another organization operates. This is another email from Penny, Rita, Will Burley, Don Brown, Betty, Maria, Lynn, Pat, Lillian, and Sue. It has to do with a properly called meeting. They wanted to know why the bylaws were done by telephonic vote rather than a properly called meeting. Both the current bylaws and the statute provide that anything that can be done at a meeting can be done through telephonic voting. Article 3G of the current bylaws provides telephonic voting and other electronic means of voting which have been proven successful being used for elections, amendments to the Constitution, and other issues authorized by the Board of Directors, period. And then the statute says, Action required or permitted by this chapter to be taken at a meeting of the members may be taken without a meeting if the action is taken by all the members entitled to vote. And there's ballot voting as well. Action by ballot. Any action that may be taken at any annual, regular, or special meeting of members may be taken without a meeting if the membership organization delivers a ballot to every member entitled to vote on the matter, and then they set forth what's in the ballot. So, so it's clear from both the current bylaws and the statute that you are not required to have a meeting. And in fact, I think that having it done electronically probably increases participation because not everybody can attend the meeting, either because of their physical situation or because of expenses or just other conflicts. There is a provision in the law that says that in lieu of turning over the membership list to the members, the organization can send if members have a right to communicate with other members, and one way to facilitate that is to give any member who requested a copy of the membership list. Alternatively, the organization can say, send me what you want to send to the members, and we will transmit it on your behalf. And so the organization elected to proceed under that provision. The provision, the notice that was sent out to everybody, and I know exactly what it said because I helped draft it, said that the board will transmit anything that a member wants to communicate without editing it or without comment unless it contains material that is defamatory or constitutes invasion of people's privacy. And those are two legal terms that have very specific meanings. They're not used as a pretext. It just means that you can't ask the organization. Defamation and invasion of privacy are torts, of which the person, if they participate in them, can be held legally liable. And I didn't want the corporation to sort of get extended or pick up that liability for the mere act of transmitting someone else's materials. This person says that they complained that they said that that the organization will only transmit, and they use the quotation mark, acceptable material. That's not correct. It's defamatory or constitutes an invasion of someone's privacy. That's a very narrow exception. They then comment that one of the board leaders talked about some of the people, it says, wishing to be in control of our own communications and not believing that a decision about whether or not communication is acceptable should be relinquished to the GDUI leaders. Again, that's an overbroad characterization of what's in the notice. Who have characterized our concerns about the proposed bylaws as vicious and us as a lynch mob. We have the response completely unacceptable. Look, I've seen a lot of communications back and forth over the last 2 years. And some of them I would not necessarily use the word vicious. It's not how I would phrase it, but I would use the word disappointing and off-putting. And it's not, after 2 years, tempers get frayed, and people are upset and hurt by different communications. So to say that someone used a word or something that you don't like, maybe in a calmer moment they wouldn't have, but given all that's gone on, I think a little sympathy for how it feels to be on the other side would not be inappropriate. Just my feeling. Now, the GDUI is charging members $1 per page to do that, and per page per member, and that reflects their actual out-of-pocket cost to do this. They actually have to use an outside person to help them do it, and that's what they're charged. That's how much they paid when they sent out the notice of the proposed bylaws vote. And so it's not unreasonable for them to pass along their costs to the people wanting to make the communication. Let's see. already been addressed. There is an email specifically from Kevin Frankenberger and Don Brown, so I'm not sure whose words are whom, entitled Attorney versus Parliamentarian.
Just want to let you know that Kevin Frankenberger is not a GDUI member, although Don Brown is.
Okay. This is one case where I would say the tone of the email is disappointing. I'm sure people may not have intended it to be off-putting, but and may not see it that way. But for someone on the other side, it was an interesting email. Okay. Since some of this is repetitive, let me just go through the various objections that Mr. Brown raised. Granting the president the authority to set the agenda and rules of conduct of the meeting of the members. Democracy, member input, question mark. Again, that's right from the statute. Granting authority to the board to act alone to amend the bylaws of the future, except for 5 areas where the members are to vote on those issues. Again, that's from the statute. That's what the statute provides, and it's a very common. In fact, it provides more rights than most membership organizations. Section 601, function of the board of directors, the new bylaws grants the board exclusive power on all matters of the corporation. That's not true. They do run the day-to-day operations, but they don't have exclusive powers. The members have powers to elect directors and remove directors with or without cause, and they have certain rights as to the membership. That the board is the final word. That's not true. They do that. Again, he raises whether we have to have a record date. That's not true. There must be a record date. The only question is, how is it set? They talked about allowing the membership list. We just talked about that. I'm not going to do that. Eliminating Robert's Rules of Order. Again, I'm not going to do that. Basically, the next thing, overlooking the most important aspect of the membership organization, that being the right to debate issues in a meeting, the right of members to, the language about whether the members can hear or read or hear the proceedings as they occur. Again, I think I explained that as they occur is really more with respect to reading the things. Conference calls, by their definition, are simultaneous communications, and so I think it does comply with the statute. An annual meeting of the members shall take place on the date in the second quarter. The president will delegate the time. The question, when to schedule it. Inability or reluctance to compile accurate membership lists. There's no inability or reluctance. They did. The D.C. statute allows change to the members list to be besides no. You can still communicate with the members. The board's power is greatly increased and the rights of the members greatly reduced. That's not true. I think there are many instances where the members' rights have been increased, i.e. elimination of appointed directors is one example. Perceived right to violate portions of the current Constitution. No, that's not true. I'm not sure I even understand what that number 12 is. Okay, here we go. Mr. Brown, there is provision in the current bylaws that says if there is a provision in the bylaws that conflicts with the higher authority, such as the state law, then that higher authority controls. That's right. It does. You don't have to have that in the bylaws. That's just a fact. It's like the sun rising in the east, setting in the west, statutes trump bylaws. That's the fact. And he says because that provision is here, we don't have to amend the bylaws to remove any provision in there that by its terms conflicts with the statute. I respectfully disagree. That's like saying you don't need brakes because your car has an airbag. You should not have anything in your bylaws that contradicts the statute. It's true that if you do, the statute will control and the bylaws won't, but you're not supposed to have something that violates the law. You really aren't. It's not considered acceptable practice. And no lawyer would draft a bylaws provision that violates the law on one hand and say, well, it's okay that I drafted something that violates the law because I have a provision here that says, even though it violates the law, we're not going to pay any attention to it. That's not considered an acceptable practice of law. More to the point, it's not even good business. I mean, you're going to have a set of bylaws. People are going to figure out, what am I supposed to do? And they're going to have to try to remember, oh, yeah, Section 4, we ignore that because that's illegal. Section 5, or is it Section 6? Is it Section 6 or Section 5 that we're supposed to ignore? I don't know. Can anybody remember? Can you call somebody? Look through the minutes. See if you can find something. It's a confusion. The bylaws are there to help people know how to conduct the affairs of the organization. And if there are several provisions in this that are inoperative because they are illegal, then it doesn't perform its essential function, which is to tell people how to conduct meetings, how to conduct elections. And to say that somehow it's acceptable to keep illegal provisions in your bylaws because you have this clause that says state law trumps the bylaws, that's just doesn't make, in my mind, it's not a very good answer. You're supposed to have bylaws that tell you how to operate in a way that's consistent with the laws, not how to operate in a way that's inconsistent with the laws, and which, if you followed them, would get you into legal trouble. So, it just doesn't help. Let's see, I'm going through all the provisions here as I read through them. Again, it says that GDUIs, there is assumption in here that members at the board at annual meetings cannot make motions or propose resolutions. They're, again, not true. There is nothing in the bylaws that prevents people from following Robert's Rules of Orders, again, except as provided in Article 2. Removal of officers, the board of directors, the officer appointed as the board officer being removed unless the board provides the board and the officer. Anyway, there's more about not having to amend the bylaws. So I guess my response to Mr. Brown and Mr. Frankenberger is, I think I've addressed most of the substantive provisions, and again, I just think there's no good reason. In fact, there's a lot of really bad reasons not to amend the bylaws to comply with the law, not the least of which is the difficulty in trying to keep compliant and not getting legal trouble. So I think that's, I have one more, a couple more. Someone wanted me to go provision by provision. I don't think that's, we've kind of done that already. Okay, someone, Ellen, was concerned about the legalistic tone. I apologize. I'm a lawyer. What can I say? It's a legal document, and so it's going to sound like a lawyer. More about ACB. Maria Hansen asked about the 25%. And again, I think I talked about that. Okay, that's the same one. Different version of the email. Okay, so that's it, Lori. I've gone through all the written questions.
All right. Okay. Thanks. All right. Okay. It's about 8:30 now, so I would like to ask you, how long do you want to go with?
I'm fine answering people's questions.
Okay. All right. Okay. So I'd like to, first of all, thank you very much for doing another overview, and I would like to remind everybody that the recording of the first call that was held on March 20th, that recording is available on our bylaws information line, and that you can listen to that, and this recording will be available then as well. There's also it's been recorded in an MP3 file, and that information will be widely circulated, and if you call the bylaws information line, you can get more information on that too. Okay, so without further ado, I will remind you that to get into the question and answer queue, you press *6, and then you press 1 to get in the queue. Okay, and we will take as many calls as we can. On March 20th, there was one caller who was remaining in the queue at it was after 9 o'clock, and our legal counsel, who is our guest, had already announced that the call she was on would be the last call for the evening. The person popped into the queue at the very last minute, and we were winding up. So sorry that we didn't get to your call, but I think it's the same telephone number here, so we are going to take your call first, and your area code 562.
Miss Regina Hopkins.
Could you please tell us your name?
It's Lillian Scaife. And
hi,
please,
Lillian. And Lillian is a member.
Okay. Hi, Lori. Please do not mute me. A point of clarification: when you were talking about Kevin and Don Brown, and you're talking about confidentiality, Don Brown is not the parliamentarian. It's Don Stevens. And I think you owe him an apology. You went on talking about Don Brown as Kevin Frankieberger and Don Stevens.
Okay, in that case, I apologize if I got it mixed up.
Yeah, because you kept referring to Mr. Brown over and over again, and that was parliamentarian. Don Brown is a life member, and I don't know the status.
No, Don Stevens is not a member of GDUI.
Okay, but the parliamentarian Kevin Frankieberger, that's Don Stevens.
And also Mr. Frankieberger is not a member of GDUI as well.
Okay, but she was referring, Lori, to Don Brown going through that whole paper, and it wasn't
Okay,
Don.
Again, I apologize. It was a mistake on my part. I thought I misunderstood.
Okay.
Lillian, did you have a question?
No, I just want a clarification of that, because I thought that was, you're talking about confidentiality and just keep repeating his name over and over.
Did you have a question last week? Was this your phone number? Were you the person that was remaining in the queue?
Yes, I did have a question. I didn't pop in and out. But my question last week is, what was the rush on this?
This is a great question, Lillian. That's a great question, and I appreciate it.
I want Regina to answer it.
That's who's going to answer you, Lillian.
The rush is, we're 2.5 years late. There's not much of a rush. I don't think a rush. And we've been working on this project for about since before the Christmas. The board reviewed it, took a month to go over it. The members have been given 45 days notice. So I'm not sure that it can be properly characterized as a rush. It's not timely. The bylaws should have been amended 2.5 years ago, and so we're behind. And this has been a process that has taken 4 months through the committee the Constitution Committee, headed by Mary Beth, then through the board, and now 45 days process through the members, and that is, in fact, what's set forth in the current articles, the current Constitution, which is 45 days advance notice. So, I don't think it's, I guess I don't think it. I'm not sure I understand where the rush comment would be coming from.
Okay, thanks, and thanks, Lillian, for your question. The next person is a wireless caller from area code 240.
Yes, hi.
Could you please tell us your name?
Yes, this is Susan Crawford. Can you hear me?
Yes.
Yes, we can hear you,
okay,
and she is a member.
Okay. So I come at this from a slightly different perspective, and so I have a question. I'd just like to share my perspective. In enforcing civil rights, consumer organizations want entities to follow the law. They want entities to follow the federal law, even if it was passed 20 years ago. It very often meets with extremely hostile resistance. And why do we have to rush it? And can't we do it a little bit at a time? We'd like to follow this one, but not that one. We'd like to think about it. And consumer organizations generally insist that, no, you follow the law now. You do it all at once. You adopt best practices. You adopt model policies. In fact, you adopt and enforce and maintain a whole series of policies, and we insist that they come into full conformance with the law all at once. I'm seeing a very similar reaction here, which is quite honestly enormously surprising to me. And my question is, in your experience, Regina, how has this kind of resistance, how has this resulted? I mean, are there other boards, are there other membership organizations how have they gotten past the barriers that seem to be the barriers here? And how do we get past them to adopt bylaws which sound absolutely wonderful to me, and I appreciate all the professional and dedicated work you've done and to work on this. Thank you.
Okay. Well, thank you. I have to say, how have other organizations done it? Bylaws are usually a snooze, I have to say. Yes. From a legal perspective, it's hard to get lawyers to do it because it's considered kind of boring and tedious work because they're pretty formulaic and there isn't that much controversy. So this is an unusual situation where you have this amount of discussion over what is considered pretty straightforward stuff. I think it's only, I would say I think it's symptomatic rather than the bylaws themselves. I think there is a level of distrust within the organization that is unfortunate and sad. I think it has detracted from the organization. And I guess I would say that, I think that the time has come. My advice to everybody is to draw a line under the past and move forward in a positive way. I don't get the sense that, if the current members of the board really wanted to nail somebody, they could have done it back in the fall of 2012 when people did things that were unauthorized by the statute. They could have taken legal action against them, and they really wouldn't have been much of a defense for them, for the people who did it, because it was clearly not authorized by the statute or by the bylaws. But they didn't. And so, I think that it's time to sort of, everybody to sort of, put the past behind them and to move forward. I think that that's what, certainly everybody I've talked to on the board, that's what they want to do. They want to move forward.
Well, I definitely can affirm that, Regina. As GDUI president, I can definitely affirm that's my goal. That's the goal of this board, is to move forward. And yes, there was a lot of pressure on me to exact retribution and to, take legal action against various people in GDUI and ACB, and that was not the path that I thought would be the most healthy for the future of GDUI, and I have tried very hard to work with people and to move GDUI forward. So, I appreciate your speaking out on this, and thank you, Sue, for your comments, because yes, we are a civil rights organization, and yes, we do insist on public entities and private entities following the law and preserving our civil rights. And I think, we should expect the same law-abiding practices of ourselves. Thank you. The next person in the queue is area code 203.
Yes,
Could
good
you
evening.
Please tell me your name?
This is Ellen Telker.
Hi, Ellen, and we know you are a member as well. Thank you. And you have a question?
I had sent in some questions, and I don't believe they were answered.
Okay, let me just read what I have from you. I thought I had sort of addressed it in a more general way. Okay. Let's see. Thanks for your response. Okay. I think it would help us to heal if we put dogs and handlers right in the beginning and not record dates and stuff. The document needs to be warmer and not so cold and legalistic. I'm sorry this happened. Okay, but then there's some personal comments from you. That's the question I had gotten to me. Was your concern that it was legalistic?
No, my question was, why couldn't the purpose that was stated in the old Constitution, why couldn't that be put in here? I think it would help a lot to heal, because we're here to advocate for guide dog teams. That's the purpose of guide dog users. And I think all of us who are members, who care about the organization, that's what we want to do. And I think it might help if people could see that right in front of them. Maybe they'd say, well, I maybe don't like this person. This person has hurt me badly, but let's get on with doing what we were formed to do. I think why couldn't it be there? You're going to say it doesn't have to be there. And all right, it doesn't have to be there, but why couldn't it be there?
Ellen, I would like to share with everybody that we discussed this at the time that the bylaws was being put together, and we had the option of copying the language word for word out of the Articles of Incorporation and inserting it, or simply stating that the mission is what's in the Articles of Incorporation. And after careful thought and knowing that there may be amendments to these bylaws in the future, we kind of were trying to preserve, we didn't want anybody to accidentally amend the language of the Articles of Incorporation, which can't be done. And so the thought was keep it a shorter document and just say that to refer to the Articles of Incorporation. But what I would like to say is that if you would like that language directly copied from the Articles of Incorporation to go back in, I, as a board member, I would respectfully request that you vote to please adopt these bylaws, and then vote it, at your earliest opportunity, at the next opportunity to do so. I would encourage you to propose an amendment to add the language in there, copied word for word from the Articles of Incorporation. And anyway, I'll Regina, did you want to say anything about that?
No, I think that's fine. It's something that the board can do after the bylaws are adopted, or if there's a strong sentiment on the members. That's, it's not intended to diminish the mission, rather than to just create a more simple and unified document. That was, like I said, I sort of view it as a legal document, but there's nothing is intended to diminish the mission of the organization.
So the amendment that would add the Articles of Incorporation language in would be the type of amendment that the board could actually effect. Is that correct?
That's right.
All right. Well, then, Ellen, we could handle that after these. Hopefully, if these bylaws are adopted, the board could, at its next board meeting, which would be, in May, following the vote, the board could take care of that and add the language back in just as you have recommended. I think that's a wonderful suggestion, and I would definitely bring it to the board. Thanks.
Okay, and I believe I had another question, too, that I had sent in. I thought, and if I'm wrong, I'm wrong, but I thought that the board used to be larger than 6 members and the officers. I'm wondering why it was made such a small board.
I think what's in the current bylaws. The current bylaws have, let's see, it has the officers, it has the 3 contract affiliates, so that's 3, and I think they have 3 more. So they have 3 elected members, the immediate past president, the officers, and the 3 contracts, affiliate liaison, those 3 people, and that's what it is now. It's the same number.
Okay, thanks, Ellen. The next person in the queue is Betsy Grenovich from Georgia, and we know you're a member for sure.
Hi, Tina, this is Betsy. I have a question for you. If the bylaws do not pass, can the election still go forward for the officers?
They can still go forward, but you can't follow the provisions in the current bylaws. You'd have to follow the statute. Would have to, still have to have a record date. You'd still have to give out notice of compliance with the bylaws. You'd still have to do everything that's in the current bylaws. But not the current bylaws, in the proposed bylaws. The procedures set forth in the proposed bylaws would have to be followed. You can't follow what's currently in your current bylaws. You're not in compliance with the statutory requirements.
Well, Betsy, I hope that the bylaws do pass because we've been advised by legal counsel that this is good for GDUI, and we were advised by the AG's office in 2012 that GDUI needed to get itself into compliance. And so I would sincerely hope that you would encourage your friends to vote to adopt these bylaws and then work with legally compliant bylaws to bring GDUI forward in a positive way. The next person, let me just try to read this. Area code 386.
Good evening. This is Doug in Daytona Beach. I have 2...
Hi, Doug. This is Doug Hall, right?
Yes. Hi
yes,
there.
And Doug is a member.
I have 2 points that I would like you to clarify for me. First of all, Regina, you mentioned earlier about that the board would set policy. But when you went over the statute, I didn't hear you say that the statute says the board sets policy.
Let me read you again what the board.
That is a big point.
Let me read it to you. Let's see. Okay. Just a second. A nonprofit corporation. This is 406.01. A nonprofit corporation shall have a board of directors. Except as otherwise provided in the statute, all corporate powers shall be exercised by or under the authority of the board of directors of the nonprofit corporation, and the activities and affairs of the corporation shall be managed by or under the direction and subject to the oversight of its board of directors. So it doesn't say policy specifically, but that's all corporate powers, is including the power to set policy.
Well, in organizations that I've dealt with bylaws, normally it says that the board of directors shall manage the organization as long as it does not conflict with or change policy set by the membership.
What I would say to that is, I'm not sure. I saw that in other bylaws in the GDUI current bylaws.
That's the way ACB is.
It's the way it is now. I mean, let me just, if I may, I wouldn't recommend that for this reason. The facts change, things change, circumstances change, and I think it would be wrong and not wise, and probably not inconsistent with the general fiduciary duties of the directors to say that they can't make changes. Let's suppose that the members adopted a budget that said we will spend $20,000 on X, and there was a financial emergency. Under your interpretation, the board would be stuck. They'd have to spend the $20,000, even though it may cause financial distress to the organization. You would want the board to have the authority to say, notwithstanding what the members voted on in terms of a budget, we are not going to spend the money. We're going to make a different decision. You have to give the board the flexibility to make changes like that to deal, because facts on the ground don't stay static. And there are remedies. You can vote them out of office. You can remove them with or without cause. You can elect different officers. There's a lot of remedy. If you think that the board is not behaving in a way that you want them to behave, you have a lot of remedies to deal with it. A board of directors elected by the members is kind of like electing a member of Congress or a member to city council or something like that. You're electing them for their judgments and their ability to manage your affairs, the affairs of the organization, subject to the fiduciary rules of duty of care, duty of loyalty, duty of obedience. And so, it's not, the board and the members are not supposed to be doing the same thing. The board, the members elect the directors to manage the affairs of the corporation in general. And there are things that you can do. The board, the members can propose an amendment to the bylaws if they want to change it. They have a lot of ability to come in and make changes to the bylaws, to remove members, do all sorts of things to make sure that the direction of the organization moves in the way that they want. But you don't want to say that just because a resolution is adopted by the members that the board can never change it, regardless of the change of facts on the ground. I just think that's tying their hands too much. It interferes with their ability to manage the affairs of the organization in a way that's consistent with their fiduciary duties.
Okay, I'm an officer of another nonprofit which is run pretty much by the board. So what this sounds to me like bylaws that are saying that the organization needs to be run by the board. My next question I wanted clarified, and Laura,
Doug, we are generally speaking taking one question per person, and we do have other people in the queue.
Okay.
Would you put yourself back in the queue?
Yes, I will.
Okay. I'd appreciate that, because I just want to give the next person a chance.
Okay.
It's late. Thanks.
Thank you. Uh-huh.
Okay. The next person is Margie Donovan, who is also a member of GDUI.
I'm sorry, did you say it was me, Lori?
Yes, I did. Hi, Margie.
Sorry, it got cut out. Thank you. First of all, Regina, thank you very much for all your hard work you've done on this. I really appreciate it as a member. I have kind of a two-part question that concerns me. As I understand the proposals, there are proposals mixed in that we absolutely need to pass because it has to do with D.C. statute. and then there's proposals mixed in that are kind of GDUI desirable changes. So can you confirm quickly, yes or no? Am I correct on that?
In a very broad way, yes.
Okay, great. So my concern is I'm not quite sure why you may have recommended, or the board is elected to have this as one vote. As I understand, it's like it's all or nothing, which I think is really unfortunate. And my question is, if this does not pass, what does that mean for the future of GDUI?
I'd make one observation, and then I'll answer your question. I think it's much more common than and when you have to make this many changes to a bylaws. When I said yes as a general rule, we made some changes to the committee section. That's not required. The membership voting had to be completely rewritten. It just was, there are certain whole articles that have to be rewritten. I would say in 99% of the cases when you're making these extensive changes that a lawyer is going to amend and restate the bylaws. They're not going to try to because it becomes almost impossible to read, just as a practical matter. Insert, this language here and change this language here and insert the there. And, it's one thing if it's just a few minor changes, but when it's this extensive, I think it's just almost virtually universal practice to just amend and restate the bylaws. And when you're going to do that, you're going to put in the desirable stuff as well as the mandatory stuff. And most of the desirable stuff is not controversial. I got to tell you, the stuff that everybody's focusing in on, almost all of it is required in some form. And there has to be some provision. There was some flexibility, whether you do A or B. And, so you have to make it to choice. Do you do A or B? How many members does it take to call a special meeting? You have to pick a number between 10 and 25. So there was some choice there. There was an element of choice there, but you have to have some provision. Within that frame of option. You have to have some provision for a record date. You could do X, you could do Y, but it has to be addressed in some fashion. So I think there's, a lot less there in terms of totally optional stuff than people appreciate. In terms of what happens if you don't do it, I think there's a couple of things. You cannot hold meetings in accordance with the current Constitution. You just can't because you're in violation of the statute. If you do. You have to ignore what's in the bylaws. It's one of those things where it could bite you. It could come back to bite you never or next week, and no one knows. And the way it comes back to bite you is a question of you're in a legal dispute with somebody, or some question comes up, and the question is, were these directors validly elected? Were the officers validly elected? Is this properly authorized by the corporation, et cetera, et cetera? And the answer is arguably no, because you didn't do it. You did it. You didn't comply with your bylaws, you didn't do the statutes, or there's a gap there. You're out of sync. And so someone could say, well, we don't have to abide by this contract because you weren't authorized to enter into it because you weren't validly elected in accordance with your own bylaws and statute. I used the example that came up a couple of years ago. We used to have a mayor, he's still in the city council, called Marion Barry.
Yeah.
Well, it's a very controversial mayor. And his ex-wife, with whom he maintains good relations, who knew, ran a very well-known nonprofit in D.C. that taught young people, inner-city kids, tennis. And she had a lease from the city at a very low rate, like $1 a year or something like that, to use their tennis facilities, their public school tennis facilities. And unfortunately, there was a mayor who was in office at the time who did not get along with Marion Barry. and she was out of compliance with the D.C. statute in corporation law, and they used it as a pretext to cancel the lease. They said, you're not in compliance, bad on you, we're negating the lease, and her nonprofit folded. Is that likely to happen? Probably not, but you only want to take the risk? I mean, it could happen at any time. Something comes up. You get sued by somebody, someone's in a car accident, something happens, and all of a sudden you're in court trying to explain, yes, notwithstanding the fact that we've totally operated inconsistent with the statute or inconsistent with our bylaws and inconsistent, we're still, please don't nail us for it. And so it's kind of Russian roulette, if you will, that you're playing, and like I said, you may always come up with an empty cylinder, but then again, you may not. And I can't, who knows? So it's a risk that you shouldn't run, and no lawyer would advise that you run that risk.
Okay, thank you.
Thank you.
Okay, the next person in the queue is Maria Hansen, and Maria is a member. Maria, do you have a question?
Hi, Regina. Thank you for speaking with us tonight. My question has to do with Article 9, indemnification. There are a couple definitions that are lifted directly from the D.C. Code and put into the bylaws, such as interested director, interested officer. There's one definition that is not included, though, under 29406.50, Section 7, party.
Hold on.
And in a way,
I got to turn to that section.
Okay. 7 under that.
406.57?
406.50 and then 7.
50. Oh, party means an individual who was or is threatened to be made.
Yes. And under that, for those who don't have the code in front, it says party means an individual who was, is, or is threatened to be made a defendant or respondent in a proceeding. And my question is sort of a couple parts. One, you alluded earlier that it was strictly as a defendant. And we do have board insurance, and I think that's where the indemnification would come from. My concern...
let me just say, the insurance is typically used to fund the indemnification.
Yes. But the reason I'm asking this question was at the last board meeting, twice there were jokes made about the board engaging an attorney to protect the organization from
Maria,
libel.
that's not true. There was nothing in the business agenda, and I don't know what jokes you're referring to. Yes, excuse me. Please don't misrepresent anyone. If you have a question, please ask your question.
Hello, Maria. What's your question?
Hi, Regina. I'm sorry, they're bouncing back between muting and unmuting. My question is this strictly, which I would hope for the purposes of, as the language says here, if somebody is a respondent or defendant in a proceeding, because I just want to make sure that there's no expansion of that language in the proposed bylaws.
There's no expansion. It's designed to track the statute. It's when someone is a defendant.
Okay,
or a potential defendant.
Yes.
They're being sued, not or threatened to.
Absolutely. Thank you.
Okay.
Okay. Thank you, Maria, for your question. The next person in the queue is. Hold on. Let me read this. Penny Reeder, and Penny is, of course, a member. Hello, Penny. Good evening.
Okay, I think I'm on now. Hey, Regina, thank you so much for spending so much time with us and I hope my letters haven't driven you crazy. And I'm not the only signer. I wanted to.
You're just the first. You're just the first signer.
It's my name is the first one, I know. So I just wanted to clarify. I know Lillian talked about her perception and the perception of many people that there is a rush, that there is sort of Damocles hanging over our head if we don't pass these bylaws. I wanted to clarify just for a second why people feel that way, or why people have been made to feel that way, because I've been a member of GDUI for a while now, and we have passed other constitutional amendments, now called bylaws, in the past at membership meetings. And at those meetings, people had a chance, one, to hear the bylaws and maybe at the beginning of a week, and then think about the bylaws, and then maybe they would come up for a vote later in the week, and then maybe someone who was presiding over the meeting would say, you may have 5 minutes to speak in favor of this amendment, and you at number Y may have 5 minutes to speak against it. And I think people felt that they had more opportunity, one, to understand the meaning of the amendments, and two, to try to persuade other people to their point of view. Now, there's no way for that kind of back and forth democratic debate to happen in this circumstance. And I think that's where we are. There's no way for someone to say, I'm sure that if we were in a meeting, someone would have already said, Madam Chair, I want to raise a point of order. I want us to consider these bylaws one by one, and I am pretty sure that would have passed. But there's no way for us to do that.
Can I just say?
Yes, please, I'm finished. So go ahead and please answer my question.
It should not do that. You shouldn't do it one by one. That's a mistake. It's a real mistake. These documents are integrated wholes. You can't sit there and say, I'll take 401, but not 403, because they make reference to each other, they are dependent on each other, they build on each other. You can't do it. It's bad practice. You either accept them or you don't, but you can't sort of pick and choose. I just think that would, it doesn't. Second, there's nothing wrong with doing it the way they're doing it. It's clearly permitted by the current Constitution. It's permitted by the statute. I think, it allows some people to participate in the vote that otherwise couldn't make it to the meetings. There certainly has been a lively debate and discussion of these bylaws over a period of time. We had one call, and then a week later we had another call for people to ask more questions. And as I said, there has been a lively debate about the efficacy of them. But I got to tell you, the one thing I don't think you should ever do is vote on these section by section. I think that just lends itself to really screw up bylaws, because you end up with, let's suppose you adopted Article 4. How would Article 5? What provisions govern the board? The old provisions? How are you going to amalgamate the two provisions? I just don't see how it works practically or in any sort of rational way. And again, it's not something a lawyer would advise you to do.
Well, I appreciate your
and Regina,
answer my
as
question.
you know, we discussed this very intensively among the board when we all talked with you on the board call, where the full board participated in discussions of this, and we really appreciated the fact that you have taken so much of your time and patience to really try to explain exactly what is showing due care for GDUI. I mean, the thing is, as you've told us, and as we were actually informed in the spring of 2012. And again, I just have to repeat, I don't know why the Constitution Committee of 2012 did not begin addressing this. I don't know why. I wasn't on that committee. But I can say that GDUI has known for 2 years plus that it needs to get its bylaws into compliance with the law and good practice. We knew that it was not in compliance with the law because attorneys have told us. We knew that it was not in compliance with good practice because 2 independent certified parliamentarians have told us that. So I can't tell you enough how much I appreciate all the time, because you have really guided us through this process. And GDUI is so fortunate, and again, this is why the board has wanted to have these informational calls. We are so fortunate to have this legal assistance, and I just can't thank you enough.
Well, thank you. Do we have another question?
We have one person in the queue who is a repeat question person.
Okay, that's done. Okay.
Okay.
Go ahead.
Margie Donovan is back.
Oh, okay. Is that not back?
Thank you. Excuse me.
There is one more person after Margie as well now.
Okay.
Regina, you've obviously been privy to a lot of information, and I have actually 2 questions for you. One is, I'm fairly clear I heard you state you've been involved since 2012. And
well, let me just clarify. I was first approached in 2012 by Bernard Ruskin from the D.C. Attorney General's office, who asked me if I could help. Normally what we do is we match nonprofits with pro bono legal counsel, and so I was first approached then. I was contacted both by Becky Barnes and by Laura Mehta. I think I said last time, I don't know if you were on the last call, I was completely transparent to both of them, and so that they knew that I was talking with each of them, and that what the substance of the conversations were. Ultimately, Becky Barnes stepped
right.
back, and so I dealt with Lori. We matched them with pro bono counsel. I had some intermittent involvement at that point, and then more heavily involved in the last 4 or 5 months.
Okay, since Gottlieb backed out. Okay, so then my second question, I'm really interested in your legal opinion on this. Given that you've been involved, you know some of the ups and downs and ins and outs. I've heard you say tonight that the membership can call a meeting or or decide to, for lack of a better term, expel or toss out, or whatever term you choose to use, any board member, president, vice president, etc. However, I also heard you say, I'm sorry?
With or without cause. They don't need to prove
Right. But however, I also heard you say that the board has elected not to reveal the membership list to its members. So let's say, for example, that I decided, I don't like our vice president. I think that, but I don't even know who our vice president is right now. But let's say I decided that I want to start a campaign to toss our vice president out. The only way I can do that is to send a letter and pay my $1 per page to do that. Now, based on, and I'm going to ask you your legal opinion, based on what's gone on in this organization in the past 2 years, and I've been kicked off of all email groups because of expressing my honest opinion and not attacking, how do you really see this coming to fruition? If I wanted to start a campaign and send a letter, I don't see that I'm not going to say this board, that a board would actually honor my legal rights.
Well,
Margie, we will honor your legal rights, and you were not kicked off of any lists.
Lori, let me just answer the question. You would have the right to either ask for the list or have an alternative method of communication. It's not optional on their part. They're required to do it. In the same way that they legally are required to give you the list of the members. I mean, it's one or the other. They either mail it out without comment to the membership on your behalf, or you get the membership list. It's not ignoring it is not an option. It just isn't. And so it's designed to so you can do that. You can do that, and you only need 25%. So you don't even need to do it. You don't even need to do it to the whole membership list. I mean, it may be advantageous to you, but so in that regard, you don't have to. But so that's what my response is. They have to. It's not optional on their part. There's no discretion on their part. They have to provide you with a reasonable alternative to giving you the membership list. That's what the statute provides.
And I would just like to clarify, first of all, Margie, you were not kicked off of anything. And the second thing is that the reason that the board has elected to use the alternate provision is because the board has a privacy policy to guarantee the privacy of members of GDUI, that we will not give any member's information out to anyone without that member's permission. We do believe it's important to protect the privacy of members, and we've been requested to do that by several members who don't like it. For example, ACB requests people's telephone numbers and other information, and a lot of our members do not want their telephone numbers to be passed along to anyone. So we do have other people in the queue.
Let's just do a couple more. Let's do a couple more, and then we'll wind it up.
Okay, there are three. There are three people currently in the queue. How would you like?
We'll do those three. We'll do
these three. Anybody who is not currently in this queue at this exact moment, we will not take your call. Okay, tonight because it's late. Okay, 386 area code, please.
Hi again, Lori. This is Doug Hall again.
Hi, Doug.
The question I had, Regina and Lori, that I didn't ask before, was that I noticed in the proposed bylaws it says that the annual meeting shall be during the second quarter of the year. Now we know GDUI's second quarter would be April, May, and June. In the past, I believe the annual meeting was held at the ACB convention, which is during the third quarter, which is in July. So are you planning on having the annual meeting before the ACB convention when you have the elections? And if so, an annual meeting is normally more than just elections. So I'm curious to know how you're planning on doing that.
Well, Doug, currently the thing we refer to as our annual meeting is the vote that takes place in the month of May, and the board wanted to. That's what we are considering the annual meeting for GDUI.
By definition,
well,
that's
again,
not an annual meeting.
Doug, if I could just interject here, you can, I think as I mentioned, both the statute and the current bylaws say you can have a electronic vote in lieu of the annual meeting as a substitute for it.
Okay, so in other words, it would not be an annual meeting then.
Well, it's held done by ballot, so you can talk about that as like I said, both the statute and the current and proposed by all three say that's acceptable practice.
Since 2008, when GDUI went to telephonic voting, GDUI has conducted its business meeting. It has conducted its business using the terminology of annual meeting in the month of May. And the board wanted to broaden that a bit so that it didn't have to be May, that they would also have the option of April, May, or June, giving some flexibility depending on the circumstances. Like, for example, this year we had a bylaws issue that we have to take care of, and then we want to get elections in as well. GDUI has not conducted its elections, its annual elections at a convention since telephonic voting had made voting inclusive for all GDUI members who wish to take part in that. So that's the intention behind. It's actually intended to broaden it.
And I just want to reiterate that in Section 3G of the current Constitution, it specifically says elections can be done by telephonic voting.
I agree with that.
And it also says that in the statute, it says that you can do it by ballot in lieu of the annual meeting.
Okay.
So
thank you, Doug. Thank you, and it's good that you helped to clarify that because actually it was May, and we are trying to broaden it to give a little bit more flexibility depending on what resources are available in a given year. Okay, the next call is from area code 207.
Hi, Lori. This is Lynn Merrill.
Hello,
Hi,
Lynn Merrill
Regina.
is a member.
Thank you, Regina, for all of the time that you've devoted to this and looking over our questions. One that came to me as we've been going through this call tonight deals with GDUI members being members of ACB. If the bylaws pass, is it the intention that in future years, as GDUI members either become members for the first time or renew their memberships, will they also be or become members of ACB as they have in the past, or will that practice stop?
I can answer that. I just want to let you know that there was Regina had advised us that that's the kind of matter that would be taken up under a board policy. There is a board policy that will be voted on at the April board meeting that will clarify all of that.
And the members won't have any voice in that policy?
I'm sorry?
Hold on. Let me just say, the short answer is there's nothing in the bylaws that would preclude that from happening. It's just not addressed in the bylaws.
Well, it just leaves a concern because the ACB requires that the membership list be sent to them by March 15th of each year.
And that's why the dues are set in the bylaws. That's why we picked March 15th as the cutoff date.
Well, they used to be February 15th, which would give the GDUI people who are preparing the membership list that month to prepare it and send it to ACB. But if you don't have your dues in until March 15th, then how can they turn that around
Lynn?
by the deadline of March 15th? Please let me finish, Lori. Thank you.
I'm going to answer your question. There was a policy that was passed by the board at the March board meeting that addresses that directly. It's a very specific policy, and you'll see when the meeting minutes come. If you weren't at the meeting in March, you'll see that it very specifically addresses GDUI affiliates and dues and cutoffs for affiliate. We do continue maintaining the dues for affiliate members as only $8 per person, whereas dues for a member at large are $15 per person. But one of the things we ask of affiliates is that the affiliates maintain the same practice they have now, where they are supposed to have their affiliate roster and dues in by February 15th. And the reason is exactly what you explained, that it has to. We have to allow GDUI's people to be able to tabulate and get all those rosters ready, whereas the members at large who pay a bit more for their membership can straggle in a little bit longer. So we have addressed that.
Lynn, just in case the real question was, was the membership list submitted to ACB by March 15th? Yes, it was.
That wasn't the question. The basic question is, in the future, will GDUI members be a member of ACB as they have in?
Yes.
Sorry about that. Yeah. I touched something I didn't intend to. Yes, they will be. That's what I'm telling you, that the board policy that is going to be addressed at the April meeting specifically speaks to that issue. And it's our feeling, it's the feeling of the current board, that if GDUI wishes to change that question would be brought to the full membership for the membership's vote, because as our understanding is that would be something that would affect the membership and what the membership has the right to make a decision on.
And see, that's where there's a little bit of concern with some of these things not being in the bylaws and having to rely on board policy where the members have no say. The members hear it at a board meeting. They're not allowed to offer any thoughts. And I understand a board meeting isn't a membership meeting. I understand that at the top. But to have to trust that in some cases the board might take it back to the membership for a vote or not is of concern. It would seem it would just be give more confidence to the members if it was right in the bylaws.
Lynn, it would be inappropriate to put that in the bylaws because GDUI's Articles of Incorporation do not stipulate that, and that would be an inappropriate thing for us to mandate in our bylaws. However, it is definitely something that the Board of Directors can set as policy and can bring to the membership to call a question if the membership ever wishes to change that. But the Board of Directors of GDUI wishes to maintain the policy. It is not, by the way, in the current Constitution. The current Constitution does not state anything about paying any dues whatsoever to ACB. It is not there, which you should know because you used to be the
and
Constitution
I do know that,
chair.
Lori.
So
but
my point is,
now say the current bylaws.
Okay, wait a second, Lynn.
Stop.
Regina's trying to talk.
What I'm trying to say is, we understand your point. I'm not trying to cut you off. It's getting a little.
No, I think that the one thing that
Lynn, please. Regina is trying to speak,
Lori,
and we do have one more person waiting.
Okay, what I'm trying to do is, I think you're going to have to agree to disagree on this one, ladies. That's all I'm trying to say. I understand your point of view, Lynn, that you feel that if it was in the bylaws, you would prefer that it be in the bylaws. I think my advice to the board and to you is that that's an external matter. Your relationship with with ACB is an external, not an internal matter. And though it's important, and it's not something that is it's not something that's in the bylaws.
And that's Regina, I understand that.
Excuse me, Lynn, please. There is another person. There is another person waiting to speak. If you understand that, please.
But Regina is talking about.
I think in fairness to the person who's waiting to speak, I mean, you could get into a debate on this. We'll have to agree to disagree on this.
I'm not trying to debate it. I just wanted to point out that the bylaws date changed. The current Constitution says February 15th. Now the bylaws say March 15th, which is the same deadline as the ACB deadline is. That's where, the flag went up. Why is it suddenly changed? You don't have to answer that. I'm just pointing that out, that that's where the flag is. I'm not disagreeing with what you're saying.
The only point I would make is the 15th, the reason the 15th appears in the bylaws is that if you don't pay it by that date, your membership is terminated. It doesn't mean that you're not going to be a thing, or it has nothing to do with ACB. It has to do with, what's the drop dead date to get your dues in so that you can continue in good standing. That's all. If anything, you'd want it longer. You wouldn't want it to be, you want to give people more latitude than less, given the significance of the date from just that one point of view. It doesn't come up in any other context. That's the only thing I would add. Okay, next question.
Okay, we have the next person waiting, and so this is a person in the 314 area code.
Hello, Madam President. This is Nick, the GDUI
treasurer.
Is it okay if a board member asks a question?
Yes, please.
Okay.
Yes.
Well, first, I want to thank all the membership for calling in tonight and all these questions, and I hope most of your questions have been answered. Regina, also thank you for all your time and dedication. My question as the keeper of the bank here, as the treasurer of GDUI, if these bylaws do not pass and we're not in compliance, could we be penalized financially as an organization?
No, there's no penalty from the deeming an authority, not having the legal authority to act. But
could we lose our 501c3 status?
No.
No. Okay.
Because you don't have to be a valid corporation. The IRS. You don't have to be a corporation to be a tax-exempt organization. You only have to be have certain language in your organizing documents. And in fact, there are many unincorporated associations that are 501c3 organizations.
Okay, thank you.
What are the ramifications for the treasurer or anybody else whose names are on accounts for the organization if the organization should go out of compliance if someone wants to file a complaint?
It's not a ramification for the individuals. It's a question of if you go to open a bank account, and not that they would, because banks generally don't dig that deep. But if you wanted to get a loan or something like that, they'd want to go through your minutes to see that you're acting in accordance with your bylaws and the statute and stuff like that. And, they'd go through your minutes and say, we're not going to make you a loan because you're not in compliance. That's the risk that that's how it would come up in a financial context.
Okay. So, and basically, what do you recommend? I mean, the board has recommended these bylaws to be adopted, and you are the person who basically helped us by
obviously,
drafting them. What do you recommend?
I have to recommend that you adopt them. It would be strange if I didn't. No, I think they're fine. I think that. I think once people get to know them and use them, you'll find that they operate pretty smoothly. I think they're clearer and more cogent than the existing bylaws that sort of jumped around a little bit. At least from the person reading it for the first time. Obviously, if you're familiar with them, you feel it's perfectly smooth and everything. But for someone like me who read it for the first time, it was a little difficult to follow the current bylaws. And I think hopefully people find this much more organized, if somewhat legalistic. Sorry. And I would also say that I just think that, again, as I said before, I think you really do have to be in compliance with the statute. It's not really an option. I would finally like to say that if anybody has any more questions, please send them to bylaws@gdui.org. I'll be happy to respond to them. I hope that, I'd be more than happy to respond to them. I realize that, as I said before, this has been a tough time in the organization over the past 2 years. And I hope when these bylaws are adopted and the organization moves forward, when the elections are held, the organization can move forward in a productive way. Because you have an important mission, you do great work. You all should be proud of everything that you all do. And it's been tough to watch on the sidelines, and sometimes as the organization has gone through such an extraordinarily difficult period. And it can't help but diminish your effectiveness. And I think you'll be a much stronger organization once you can put this all behind you. So that's it.
There was one more person there in the queue that I hadn't noticed. Do you want to?
I can ask a question. This will absolutely be the last one. It's 9:30.
Yeah. Darla Rogers.
Okay, that's okay.
Yeah, Ms. Hopkins, and maybe you want to do this later, and maybe you already did, and I need to find it in recording. Could you prepare a summary that Lori might send out explaining how bylaws work with the Constitution, work with policies? Do you understand my question? And how they correlate.
You mean what's the hierarchy of things?
Yeah.
I'll see if I can put something together or find something to do it.
Because maybe that would make it a little clearer if we understood the hierarchy and how it actually, might govern us better. Thank you.
Mhm.
Okay, thank you, Darla. Thank you, everybody, all of the members who have called in, and all of you members who will be listening to this at a later time in the recording. We thank our legal counsel for all of her many, many, many hours of work with us on this project of getting new bylaws forward. It has been long in coming, and we were advised way back in 2012 that, hey, guys, you need to do this. So the board is recommending adoption of these bylaws, and we believe that it's good for GDUI to move us forward, and that's what we all want. So thank you all for coming, and on behalf of the board and the Bylaws Committee, thanks, and we hope you have a good evening.